introduce our speaker for today. She is one of the very few Florida Bar Board certified specialists in condominium, tough word, and plan development law in the state of Florida. And we have her here today. And Kay Bender-Rembaum is very proud to have her with the firm as well. Danielle Brennan. Danielle.
Good morning, everybody. Thank you so much for joining us. Thank you, Jeff, for the introduction. My name is Danielle Brennan. I am board certified specialist in condominium and plan development law, along with 8 other attorneys here at Kay Bender-Rembaum. We specialize in providing legal services to community associations throughout the state of Florida. I am here in Palm Beach County in our Palm Beach Gardens office. We do have offices in Pompano Beach, in Broward County, and in Tampa, Hillsborough County, and also have offices available in Miami-Dade County. Representing community associations is what I do every day, what our firm does every day. And again, so glad that you guys can join us. So we do have a lot of material, as Jeff was saying, nearly 200 slides. We will not get to every single slide, but you will get a copy of the materials if you haven't received them already. I know that they were provided about an hour before the class. You're welcome to follow along with me. I will be sharing my screen so that you can see the slides. And let's get started.
And I'm just going to mention, you go ahead and get your screen going, Danielle. Thank you for that. A couple of questions. Are we all on mute? Yes, everybody's muted. Nothing to worry about. You can only see and hear us. The way you will interact is with the Q&A. So Barry, no worries there. And as Danielle mentioned, the slides were emailed about an hour ago, but there will also be a link on the evaluation to download the slides that you're seeing here. So if you don't have them already, you'll be able to get them afterwards, plus in a follow-up email tomorrow. Back to you.
Okay, and also I want to mention, in addition to waiting until the end and listening with got your listening ears on today, until the end of the presentation in order to get your evaluation and certificate, you're also going to want to wait and stick around to the end, because we've got every board member's favorite topic, assistance animals, at the very end of this presentation. Okay, so stick around. You'll get some great information about assistance animals there. So first question, why are we here? Well, the Florida legislature has required that all board members be certified within 90 days of being elected or appointed to the board. There are 2 ways to do your certification. One is to come to a course like this and submit your certificate of having completed this course to your board. It can be done a year in advance, but certainly within the 90 days after being elected or appointed. You can also do what we like to call the Scout's Honor, certifying writing that you've read the governing documents, will work to uphold the documents and policies to the best of your ability, and will faithfully discharge your fiduciary responsibilities to the association's members. We get asked often, well, do I have to take the course every year? How long do we have to keep the certificate? Well, pursuant to Florida statute, you do have to keep the certificate for 5 years or for your uninterrupted tenure on the board, whichever is longer. But we do encourage you to come back every year, because there are changes to the law every single year. As you'll see through this presentation, there were some fairly large changes to the statute. Failure to have your written certification or your educational certificate on file doesn't affect the validity of any board decision, but if you don't have it in within that 90 days, you are suspended from the board. It's not knocked off the board, but suspended, and the board can fill the vacancy during that period of suspension. Okay, like I said, you will get some indication of the new legislative changes throughout the presentation. They're going to be marked with a couple of asterisks and underline, and hopefully I caught them all in blue as well. So let's go over some legal jargon that's really specific to condominium associations. So condominiums can come in a number of shapes and sizes. Your classic high-rise condominium, you can have your 4-plex villas, or here, even an empty piece of land can be subjected to the condominium form of ownership. What makes a building a condominium? Well, really, a condominium is like buying a cube of air. And in your declaration of condominium, there are boundaries that describe the unit that you own. They're usually called upper or lower parametrical boundaries. And the statute, Chapter 718 Florida statutes, which we'll call the act here, is more commonly referred to as the Condominium Act, is what creates that title to that cube of air. As I was saying, 718 is really the enabling legislation that creates that cube of air. Your declaration of condominium is your title document. So when you go to your deed, what you're going to see in your deed for the legal description is unit number of such and such condominium according to the declaration of condominium recorded in the official records book page. And it's always going to refer back to that declaration of condominium because that is your title document. It's not the same for a homeowners association. Homeowners association usually refers to a plat and is in existence because of common law and not because of the statute, although there is a statute that governs HOAs. We'll talk more about material alterations that was mentioned on that slide later in the presentation. So which version of Chapter 718 applies to your condominium? Well, this is really a legal question that you should be asking, or your attorney should be addressing with you when you come to them with a legal issue. But under Contract Law 101, the substantive law in effect at the time that the contract is entered into, here our contract is our declaration, the law in existence at that time is grafted into the declaration as if it's written in there. Constitutional due process rights protect us from retroactive application of laws that adversely affect or destroy a vested right, impose or create a new obligation or duty in connection with a previous transaction, or that impose new penalties. So the example I typically use is to say, I have a blue pen and I'm going to sell this blue pen to Jeff, but he has to pick it up tomorrow. So let's say tomorrow the legislature says selling blue pens is illegal. Can he still get his blue pen? Technically, yes, because I sold it to him the day before. Now, let's say I sold him the blue pen the day after. Legislature says there's a 3-day waiting period before you can receive your blue pen. Does he have to wait the 3 days? Yes, because that's a procedural law. On the next slide, that gives you a more legal definition of what procedural versus substantive is, but that gives you a practical approach to these legal terms. So procedural laws provide the means and methods for the application and enforcement of existing duties and rights, and substantive laws prescribe legal duties and rights. And once those duties and rights are vested, due process prevents the legislature from retroactively impairing those rights and duties. Some of the rights that have been established pursuant to case law are the configuration and size of a unit, ownership share in the common expenses and surplus, appurtenances to the unit. And from an HOA case, we have this one, which is once a cause of action accrues, it transforms into a protected property interest and becomes a vested right. Well, we know that we have two different types of laws. Procedural laws are things that are going to apply regardless of what's in our declaration. Substantive laws aren't going to apply because they affect vested rights. But there's surely an exception, and there is. It's called Kaufman language. So you need to take a look at your governing documents and find out what they say. What is written into your declaration of condominium? This condominium is subject to Chapter 718, or is it subject to Chapter 718 as amended from time to time? That's that magic Kaufman language. If the declaration provides that it is subject to Chapter 718 as amended from time to time, then each year's substantive legislative changes will apply to your declaration. So we know that Chapter 718 is specific with regard to condominium associations, but all associations are created, I should say nearly all, are created under Chapter 617, which is our Florida Not-for-Profit Corporation Act. And sometimes there can be conflicts between these two, but there's a statute out there that says that in the event of any conflict between 617, our Not-for-Profit Corporation Act, and 718, the Condominium Act, you're going to look to Chapter 718 for the controlling law. So, but what if there are conflicts between your documents? Okay, we know what we need to do in the event there's a conflict between the statute, but what if there's a conflict in your governing documents? You have your declaration, which is like your constitution, that's that contract we were talking about earlier. That sets forth all the rights and duties, maintenance obligations, what have you. It's really like, if you're a religious person, it's really like your Bible for your condominium association. Your articles, that's the establishment of the association itself. It's a corporate document, usually sets forth the composition of the board, certain powers, the composition of your membership, voting rights, and your bylaws. That's a procedural document. Those are your how-tos. How do we hold a meeting? How do we, in a condominium association, sometimes it will include how do we levy an assessment, and certain financial details. What if there's a conflict between any of those documents? Well, just remember the phrase, a little dabble do ya. Your declaration takes priority of your articles and bylaws, and your articles take priority over your bylaws. Mind you, there is also an exception to this rule. Sometimes the statute will say, unless otherwise defined or provided in the declaration, unless otherwise provided in the bylaws, then you will go to that specific document. So these are terms that you're probably used to using with your condominium association. Unit, that's your exclusive, the portion of the condominium property that is exclusively owned. That's what's inside the boundaries set forth in your declaration. Your condominium parcel is your unit plus your undivided share in the common elements. Common elements is basically everything that's not your unit. Limited common elements, that's typically your patio, your balcony. Those are portions of the common elements that are restricted to exclusive use for the unit to which it's assigned or appurtenant attached to. Condominium property is all of the property that's subject to the condominium form of ownership in your declaration. And association property is property that's owned by the association and used, or dedicated to the common use of all the members. So let's dive into some procedural issues here regarding members' meetings. There's a statutory reference if you guys care to look at that. Annual members' meetings, as they say, annual members' meetings happens once a year. An annual meeting of the unit owners has to be held in locations set forth in the bylaws. If not, then held within 45 miles of the condominium property. The bylaws have to provide a method of noticing meetings for the unit owners. We'll talk more about notice in a minute. And the regular election must occur on the date of the annual meeting. Special members' meetings are every meeting other than the annual meeting. Can be held when called by the board and must be held upon the written request of at least 10% of all owners, unless a different percentage is provided in your governing documents. Just a little practice note, even if your owners are not authorized to take action, if they, on that particular matter for which they want to hold a special meeting, if they provide you with a petition from at least 10% or the other percentage that's provided in your governing documents, you still need to notice the meeting and hold the meeting. Notice and agendas. See the double asterisk with the underline in blue? That's going to indicate something that's new from this last legislative session. Written notice has to include an agenda, must be mailed, hand-delivered, or electronically transmitted to each owner at least 14 days before the meeting, and must be conspicuously posted on the condominium property or the association property at least 14 continuous days before the meeting. What's interesting here is that they made the change for allowing posting on association property for membership meetings, but they didn't make the same change for board meetings, which we'll talk about later. I'm not sure what the reasoning behind that was. At any rate, the association must, by reasonable rule, designate a specific location for posting notice. If there's no condominium property or association property, which I have not, this is not an issue I've ever run into, upon which notices can be posted, you don't have to comply with the posting requirement. Unless a unit owner waives in writing the right to receive notice of the meeting, the notice again has to be hand-delivered, mailed, or electronically transmitted to each unit owner. There is a way in which you can post notice via closed circuit TV. I'm not sure how many associations continue to use closed circuit TV, but you can, and you have to show it 4 times per hour for as many days as notice is required. An officer of the association or whomever is providing notice of the members' meeting has to evidence compliance with the notice requirement by an affidavit. And that affidavit must be kept with the official records of the association. Electronic notices. This is a way the association can save some money in having to mail notices. Electronic notice can only be used for those owners who consent in writing to receive official notice by electronic transmission. The association, once they have that written consent, you have to maintain the email addresses and facsimile numbers of those unit owners who provided their consent. Electronic notice cannot be used for the recall of a board member or for retrofitting the condominium with a fire sprinkler system. Those are for our high-rise condominiums. And a unit owner who consents to receive notices by electronic transmission is responsible for removing any filters, any spam blockers to ensure receipt of the notice. Now, we have received some questions from board members about electronic notices or electronic transmission and electronic voting. Sometimes there's confusion about the two. The two are very different. We'll talk more about electronic voting later in the presentation, but the two are very different. Just because you have some owners written consent to receive notice via electronic transmission does not mean that they can vote online. It's a very different process. Members, meetings, quorums, and decisions. Remember before when I told you little dab will do you, unless there's an exception. This is one of those exceptions because you have to refer directly to your bylaws. Statute says unless a lower number is provided in the bylaws, your quorum at a membership meeting is going to be a majority of all members. Unless otherwise provided in the act or in the association's governing documents, decisions made by a majority of those members present at a meeting at which a quorum is attained is considered an act of the membership. Now, unit owners have the right to participate in meetings of the members with regard to all designated agenda items. The association may and absolutely should adopt reasonable rules governing the frequency, duration, and manner of unit owner participation. And a unit owner may record or videotape a meeting of the unit owners subject to reasonable rules adopted by the division. When we say the division, we're talking about the division of Florida condominiums, timeshares, and mobile homes. They have some rules, one of which is that they can't use audio or video equipment that creates or emits disturbing sounds or lights. But the other rules that are set forth by the division require some type of adoption by the board and as a written rule, including the requirement that they provide notice beforehand, or that they can't get up and move around their equipment during the meeting. Those are things that have to be adopted by the board. If you're interested in adopting some rules regarding video recording, audio taping, and rules regarding member participation during the meeting, absolutely contact your association's attorney and they'll be able to assist you with preparing that and providing you with guidance in adopting those rules. So we have two different types of proxies out there that our membership can use. A general proxy allows a proxy holder to vote however the proxy holder sees fit. Limited proxy is very different because the member directs the proxy holder how to cast that member's vote. For all votes that are taken by the membership in a condominium association, you're going to need a limited proxy. And there was a list of examples there, but at the end is the catch-all. Any vote taken by the membership that's done by proxy has to be by limited proxy. Unit owners may not vote by general proxy. Both can be used to establish a quorum. You cannot use proxies in an election. We have our beloved inner outer envelope system for our elections, which we will discuss later in the presentation. Proxies given are effective for the specific meeting for which they are given and any lawful adjournments of those meetings, but they don't go longer than 90 days from the date of the initial meeting. Every proxy is revocable at the time by the unit owner executing the proxy. And like I said, like I promised, election of directors. So here we go into the process. Unless otherwise provided in the governing documents, your board is going to consist of 5 members. Unless you only have 5 or fewer units, then it's 3 members on your board. Vacancy on the board occurring at the expiration of a director's term is filled at the annual meeting by an election. Generally speaking, directors' terms end at the annual meeting. This is something where you're going to want to refer to your governing documents to see if they provide for longer terms, if there are staggered terms. Back in July of 2018, a statute became effective, which confused a lot of people. And it was the 8-year term maximum limit, unless it was voted upon by 2/3 of the voting members in the election, or unless there weren't enough candidates, then a director could serve for greater than 8 consecutive years. And a lot of people were scratching their heads. Well, does this mean that if I served 10 years before, as of July 1st, 2018, I can no longer serve on the board? Well, this year it was clarified that only board service that occurs on or after July 1st, 2018 is calculated in that term, that 8-year consecutive term limitation. If the number of vacancies equals or exceeds the number of candidates, and then there's no election needed, those people are just going to be seated at the annual meeting, and any vacancies that are on the board remaining after the election of acclamation will be filled by the board. We'll talk more about vacancies later. A candidate is any eligible person who has timely submitted a written notice of their intent to become a candidate, and any owner desiring to be a candidate must provide 40 days written notice of their intent to run and has to be eligible to serve on the board at the time of the deadline for submitting their notice of intent to run. A person who has been convicted of a felony or who has been convicted of a crime in another state, which would be considered a felony in this state, is not eligible for board membership unless they've had their civil rights restored for at least 5 years. A person who has been suspended or removed by the division, again, that's the Division of Florida Condominiums, Timeshares, and Mobile Homes, under the Act is not eligible to be a candidate. And a person who is delinquent in the payment of any assessment obligation due to the association is not eligible to be a candidate. Prior to July 1st of this year, it was any monetary obligation to the association, which could disqualify them, so like a fine. But now it's been changed to assessment obligation. What's interesting here is that the delinquency, once you're on the board, if you have a delinquency greater than 90 days, you can be kicked off the board. They didn't change that from monetary obligation to assessment obligation. That is still monetary obligation. Again, I'm not sure why that is the case. In a residential condominium association of more than 10 units, or in a residential condominium association that does not include timeshare units or timeshare interests, co-owners of a unit cannot serve on the board at the same time unless they own more than 1 unit or unless there's not enough eligible candidates to fill the vacancies on the board. When we're talking about our procedural requirements, deadline requirements for a condominium election, you always want to remember these numbers: 60, 40, 35, 14. Not less than 60 days before a scheduled election, you need to send, mail, deliver, electronically transmit to each owner entitled to a vote the first notice of the date of the election. Now that's what's provided by statute. We also have to go to the Florida Administrative Code to get a little bit more guidance as to what must be included in that first notice. Also has to have the name, the correct mailing address of the association, and disclose the procedure and deadline to consent to electronic voting. Again, something that we'll touch on later in the presentation. Any owner or eligible person desiring to be a candidate must give, again, that written notice of intent to run for the board at least 40 days before a scheduled election. Unit owners can request that the association include a candidate information sheet with the mailing of the ballot and the second notice, and the candidate information sheet must be provided no later than 35 days before the election. It's a 1-pager. Only one side of a 8.5 by 11 is permitted for that candidate information sheet. The association is going to be responsible for the costs of reproducing and for the costs of mailing. Not less than 14 days, and this is new, nor more than 34 days prior to the annual meeting, together with the notice, with an agenda, your ballots, your inner outer envelopes, and any candidate information sheets that were timely submitted by the candidates. You have to send that at least 14 days, no more than 34 days. 34 days, again, being the brand new requirement. There is no quorum requirement for an election. You have to have at least 20% of eligible voters casting a ballot in order to have a valid election. The association does not get to vote its association-owned units. And although there's no quorum requirement for holding a valid election, if you're going to be doing anything else like voting to waive or reduce reserves, you do need to have that quorum in attendance at the annual meeting. Elections are decided by a plurality of the votes cast. There's no cumulative voting in election. They're held by secret ballot. You can have it by written ballot or voting machine. Again, you can also do it by electronic voting. Proxies cannot be used, as we discussed earlier, and cannot be used to fill vacancies caused by recall, resignation, otherwise, unless provided in the act. No unit owner can permit any other person to vote his or her ballot, and any ballots improperly cast must be deemed invalid. Any unit owner who violates this provision may be fined by the association in accordance with this particular statute. A unit owner who needs assistance in casting the ballot for the reasons stated in this statute that's stated here, which refers to blindness, disability, or illiteracy, can obtain that assistance in casting their ballot. All of your voting documentation, your ballots, sign-in sheets, voting proxies, anything related to a vote by the unit owners must be maintained for a period of 1 year from the date of the election vote or meeting. And any challenge to the election process must be commenced within 60 days after the election results are announced. We'll talk about recall a little bit later, but what you'll see is that 60 days tends to be the rule. So you'll have your election challenge 60 days after, and you can't commence a recall 60 days before an election. Okay, otherwise, you just have to be patient and wait for the election to happen. Verifying outer envelopes. So remember, all of our elections in the condominium are done by an inner-outer envelope system. Your inner envelope having no identifying information, and your outer envelope having the voter's name, a place for a signature, and the unit for which the votes are being cast. The association may verify that information on the outer envelope at an impartial committee meeting held on the day of the election. The impartial committee has to consist of members who are not current board members, officers, candidates for the board, or any of their spouses. It's open to all members. You notice it like any other board meeting. That's 48 hours notice, conspicuously posted on the condominium property. And again, held on the date of the election. At the impartial committee meeting, the signature and unit number on the outer envelope is checked against the list of the qualified voters. And if they voted, you check them off. Any outer envelope not signed by the eligible voter must be marked as disregarded, and the ballots in that envelope are not counted. All ballots and envelopes, including those disregarded, must be kept with the association's official records, again, for that 1 year period. So here we go into electronic voting, and a lot of associations have found this to be very valuable in obtaining quorums and obtaining votes, because it's really simple, and there are a lot of services out there which are Florida law compliant who are really helpful in getting the word out about the vote and can generate results like that. An association may use an online voting system for all owner votes if the owner provides a written consent to online voting, which is valid until they opt out. Those people are counted towards a quorum, but once you take a substantive vote by electronic voting, you can't do any other substantive vote by at the live meeting if the quorum is established by electronic votes. The use of electronic voting must be established by the board at a board meeting 14 days, noticed 14 days prior to that meeting. So it's similar to a membership meeting notice, but it is a board meeting where the board's going to adopt a resolution that authorizes electronic voting. The board resolution must provide that owners will receive notice of the opportunity to vote through an online system, establish reasonable procedures and deadlines for owners to provide their written consent, and for them to opt out of online voting. If online voting is used, the association must provide each owner with a method to authenticate the owner's identity, a method to ensure the secrecy and integrity of the election ballot, and a method to confirm that their device is communicating with the voting system successfully at least 14 days before the voting deadline. Now, again, your voting system, just ensure that it's Florida law compliant. This is usually something that's handled by their system, but just note that the association has to use an online system that's able to authenticate the owner's identity, separate the identity from the vote, transmit a receipt, store and keep the electronic votes. Again, something that the service should be able to provide. Okay, so filling vacancies. What happens if everyone quits but you? Unless otherwise provided in the bylaws, any vacancy occurring on the board before the expiration of a term is filled by the affirmative vote of a majority of the remaining directors, even if the remaining directors constitute less than a quorum, or by the sole remaining director. In the alternative, you can hold an election. Unless otherwise provided in the bylaws, a board member appointed to fill a vacancy fills the vacancy for the unexpired term of the seat being filled. Again, we'll talk about recalls towards the end. Filling vacancies is a little bit different there. When you see recalls, it's going to indicate that we're nearing the end of our presentation, terminations as well. But again, stick around for assistance animals. The officers, unless otherwise provided in the bylaws, the board must have a president, a secretary, and a treasurer. It's very common for the bylaws to require a vice president, sometimes an assistant secretary or assistant treasurer. Unless otherwise provided in the bylaws, the officers serve without compensation and at the pleasure of the board. Officers are selected by the board immediately following the election of directors. This is pretty typical. Sometimes it'll also say within 10 days. And this particular meeting is generally referred to as the organizational board meeting. Directors may not vote by proxy or by secret ballot, except that secret ballots can be used in the election of officers. And there's no prohibition in changing officers midstream. Some practice tips here when you're approaching an election. Notice a board meeting to occur prior to the election to conclude any unfinished business the board might have. This is usually to adopt a budget. Or notice a board meeting to occur immediately after the annual meeting for the appointment of officers. And this little question here, does the president vote? It's really bait. Directors tend to wear a number of hats. You have your member's hat, your director's hat, your officer's hat. When you're at a board meeting and you're voting, you're not voting as an officer, you're voting as a board member. So it's a little bit of a trick question there. Board of Directors. The officers and directors have a fiduciary responsibility to the unit owners and must act reasonably. That's using your business judgment, and that's called the business judgment rule. You can be wrong, but don't do it often. And when you're looking for insurance or purchasing your insurance or the association, you have to use your best efforts. I know a lot of associations are going through some tough times right now with increases in premiums. Your homeowners are too. So everyone's feeling the pain there. Directors must not be compensated unless otherwise authorized in the bylaws, unless it's for work performed in one's trade. And we'll talk about that when it comes to disclosures of conflict of interest later in the presentation. No board member, not even the president, should make unilateral decisions unless that power is delegated to that particular person or unless it's an emergency. The great power grab. This is something we hear often from our clients, owners saying, show me where it says you can do that. Well, really, the opposite is true. Unless otherwise provided, the corporate powers of a corporation not-for-profit are exercised by the board. So if you see a power that's in there that says the association has the power to do this, that's a power that's exercised by the board, unless it says specifically that the members have the authority to exercise that, or you're required to obtain membership approval for that particular power to be exercised. Unauthorized actions which bind the association. Okay, sometimes the board may take action outside of the context of a properly noticed board meeting. You guys shouldn't be doing that, but sometimes accidents do happen. It then happens, you notice a board meeting and you ratify the decision. Parent authority basically means that if your vendor believes that someone is representing the association and has the authority to act, signs a contract, that vendor may have full rights to rely on that authority in binding the association to that contract. The way to avoid this is to advise all of your vendors who has the authority to speak on behalf of the association. No free lunch. An officer, director, or manager may not solicit, offer to accept, or accept anything of service of value or kickback for which consideration has not been provided for yourself, for your family members, or any person providing or proposing to provide goods or services to the association. If you do so, you're kicked off the board. You may be subject to a civil penalty, and if applicable, a criminal penalty. There is no prohibition against receiving services or items in connection with trade fairs or educational programs. If you go to trade shows, a lot of times there might be like a raffle for $50 or $25, whatever it may be. That is in connection with trade fairs or educational programs. There's no prohibition in receiving those items. Email communication between board members. Board members can use email to communicate with one another, but you cannot use email to cast a vote on association matters. That really needs to be done at a board meeting. Except in the case of an emergency, notice an agenda, and we'll talk about the agenda later, of a board meeting must be posted conspicuously on the condominium property at least 48 continuous hours before the board meeting. Again, Florida legislature did not change this particular part of the statute to include association property posting. So just know that it needs to be on the condominium property for the board meeting notice, 48 hours continuous in advance of the board meeting. In addition to any of the authorized means to provide notice, you can post notice on the website. If you do, you have to send an email providing a hyperlink to the notice. So sometimes a board meeting will need to be noticed in a manner similar to a membership meeting. We talked about the electronic voting. That's going to require a 14-day notice. And these two particular times, any meeting of the board where there's going to be a non-emergency special assessment levy, or at which an amendment to rules regarding unit use will be considered. Those have to be mailed, delivered, or electronically transmitted to the unit owners and conspicuously posted on the condominium property at least 14 days prior to the meeting. Again, similar to a membership meeting, you do need to have that affidavit of compliance with the 14-day notice requirement kept among the official records of the association. Board meeting notices must specifically identify all agenda items, of course, except in the event of an emergency. If 20% of the voting interest petition the board to address an item of business, then the board within 60 days after receiving that petition must place the item on the agenda at its next board meeting or call a special meeting for that purpose. An item not included on the notice may be taken up on an emergency basis by a vote of at least a majority plus one of the board members. Such emergency action must be noticed and ratified at the next board meeting. Notice of any meeting in which regular or special assessments against unit owners are to be considered must specifically state that assessments will be considered and provide the estimated cost and description of the purposes for such assessments. So that's going to include your board meeting at which you guys adopt a budget, because that is in essence adopting all of your maintenance assessments for the year. Board meetings at which a quorum is present must be open to all owners except when you're dealing with the association's attorney with respect to proposed or pending litigation, if the meeting is held for the purpose of seeking or rendering legal advice, and board meetings held for the purpose of discussing personnel matters. Now, these meetings are closed, meaning that membership cannot attend these meetings. However, you do still need to notice and keep minutes. Any unit owner may tape, record, or videotape meetings of the board of directors. Again, the division does have some rules in place, but some of these rules require board adoption or membership adoption, depending upon how your rules are adopted. So contact your association's attorney who can provide you with guidance as to preparing these rules and how they get adopted. Unit owners have the right to speak at meetings. Again, The association does have the ability to adopt written reasonable rules governing the frequency, duration, and manner of unit owner statements, and absolutely should do that. Again, contact your association's attorney. A majority of the board present at a meeting constitutes a quorum. You can attend a board meeting by telephone conference. Just make sure that there's a speakerphone in the room where everyone can hear and participate in the meeting via that speakerphone. Can also do it by video conferencing. Board members can be counted toward a quorum and can vote via those electronic means. Unless otherwise stated in the bylaws or articles of incorporation, the act of a majority of the directors present at a meeting at which a quorum has been attained constitute the actions of the board. Again, directors cannot vote by proxy or by secret ballot, except when they're voting for officers, they can do so by secret ballot. A vote or abstention from each board member present, there's a typo there, must be recorded in the minutes. A director who is present at a meeting of its board at which action on any corporate matter is taken is presumed to have assented unless they vote against or abstain. A director of the association who abstains from voting on any action taken is presumed to have taken no position with regard to that action. A director can submit in writing his or her disagreement or agreement with any particular matter that's taken up by the board, and that can be included with the minutes of the meeting. However, it's not counted toward a quorum or counted as a vote on that particular matter. What do a golem and a condominium board workshop have in common? Now, back in the day when I was creating this PowerPoint for our firm to use, I had no idea what a golem was. I'm a Catholic girl born and bred, so I had no idea. But apparently they are both mythical creations. The mythical golem is summoned by observant Jews as a protector and guardian. The workshop is used as a mythical tool to get around noticing of board or committee meetings. Now, granted, if you hold a workshop and it's noticed like a board meeting, then there's no problem with calling it a workshop. But if you're calling it a workshop in order to avoid those notice requirements, that's where you've run afoul. Committees. Okay, so this is some relatively new legislation about the composition of certain committees. In accordance with section 617.0825 of the Florida statutes, again, that's our Not-for-Profit Corporations Act. Unless the articles or bylaws provide otherwise, the board of directors is entitled to rate two kinds of committees: board committees and advisory committees. A majority of the people on the board committee must be directors unless the committee is created by the board or is otherwise authorized by the articles of incorporation, and the committee relates to the election, nomination, qualification, or credentials of directors, or is involved in the process of electing directors. Mind you, this is in our Florida Not-for-Profit Corporation Act. For our condominium associations, in their elections, they are prohibited by the Florida Administrative Code from creating a nominating committee. You cannot create a committee that nominates people as candidates for the board. You can create a search committee that encourages people to run for the board, but you can't have a nominating committee that says you get to run for the board and you get to run for the board. That is not permissible. Advisory committees. A board can create or authorize one or more advisory committees with any number of persons on the committee being non-directors. They're not committees of the board, meaning that they can't act on behalf or exercise any of the powers or the authority of the board to bind the association to any action, but can make recommendations to the board, to the officers, and to the members. A lot of times this has to do with like improvements to the the condominium property, what have you. A committee member who is not a director has the same responsibility and fiduciary duties with respect to activities of the committee and the same liability protections as a committee member who is a director. They did create an express exemption for this particular type of committee for the requirements of under the statute for fining committees and use right suspension committees, which we'll talk about a little bit later. Those all have to be impartial committees. When do committee meetings need to be noticed? Generally speaking, you have to notice all committee meetings in the manner similar to board meetings. There are certain exceptions that can be made though. Meetings of a committee to take final action on behalf of the board or to make recommendations to the board regarding the association's budget are always going to be subject to notice requirements and cannot be exempted from those notice requirements. Meetings of a committee that do not take final action on behalf of the board or make recommendations to the board regarding the association's budget can be exempted only if the exemption is made in the association's bylaws. So like I said, baseline is you need to notice your committee meetings similar to in a similar manner as you do for board meetings, unless your bylaws provide certain exemptions for committee meetings, and know that these two types of committee meetings cannot be exempted from notice requirements. Oy vey. So you're on the board, you're not getting paid. It's a thankless job at times, but a very important role that everyone plays. How do you get off the board? Well, there are 7 ways. You can resign in writing, recall, which again, we'll talk about later. Delinquency in the payment of any monetary obligation due to the association for greater than 90 days. Criminal charges involving theft or embezzlement of association funds or property. For a knowing and willful violation of the act, the division can order removal of the officer or director. Can also be subject to fines. There's also possible criminal penalties, which we will also talk about later in the presentation. Failure to satisfy certification requirement, again, that's a suspension, not a removal. And if the board finds that an officer or director has violated conflict of interest disclosure, the officer or director is deemed removed from office. And again, we will talk about conflict of interest a little bit later in the presentation. Criminal penalties. This came into effect July 1st, 2017. An officer or director charged with any of the following crimes must be removed from office and the vacancy filled by the board for the remainder of the term or the period of suspension, depending upon what happens. For forgery of a ballot envelope or voting certificate used in an election, that's punishable as provided in section 831.01. Now 831 is a criminal statute. Theft or embezzlement of funds of a condominium association is punishable as provided in section 718.014, again, another criminal statute. Destruction of or the refusal to allow inspection or copying of an official record of the association that is accessible to unit owners within the time periods required by law. In the furtherance of any crime is punishable as tampering with physical evidence as provided in these 2 particular statutes. The second one having to deal with obstruction of justice. If a criminal charge is pending against an officer or director, he or she may not be appointed or elected to a position as an officer or director of any association and may not have access to the official records of any association except pursuant to a court order. If the charges are resolved without a finding of guilt, the officer or director is reinstated for the remainder of their term if there's any term remaining. So this particular section is like a smorgasbord of really good things that association directors should know. Budgets, reserves, and financial reporting. Again, indicating the 2 asterisks and the underlined blue indicating that there is something new this year. The board must prepare an annual budget, has to include estimated revenues, operating costs, and revenues for the upcoming fiscal year. Revenues, operating costs, and reserves for the upcoming fiscal year. Operating costs relate to your daily operations, management, salaries, office supplies, utilities, taxes, what have you. The annual budget is adopted by the board at a properly noticed board meeting open to all unit owners. And this is new. The budget must be adopted at least 14 days prior to the start of the association's fiscal year. The board must provide 14 days written notice, hand-delivered, mailed, or electronically transmitted to the unit owners together with a copy of the annual budget. The person providing the notice, again, has to sign that affidavit evidencing compliance with that notice requirement that's kept among the official records of the association. If at the budget meeting, the board makes a change to a budget item, you don't have to renotice the meeting because it was made at the meeting before the membership who's in attendance. In addition to annual operating expenses, the budget must include reserve accounts for capital expenditures and deferred maintenance. These accounts have to include, without regard to the amount, roof replacement, building painting and pavement resurfacing. And reserves also have to include any item that has a deferred maintenance expense or replacement cost that exceeds $10,000. The amount to be reserved must be computed using a formula based on the estimating useful life and the cost that it's of the replacement or deferred maintenance at the end of that useful life. You can adjust any replacement and reserve assessment annually to take into account any changes in estimates or extension in useful life. Say that you've done some repair that's going to push the remaining useful life greater than 1 year. That's something that you can adjust in your reserves calculation. The capital expenditure is any expenditure of funds for the purchase or replacement of an asset whose life is greater than 1 year, or in addition to a particular asset which extends the useful life of that asset for greater than 1 year. A deferred maintenance means any maintenance or repair that will be performed less frequently than yearly and will result in maintaining the useful life of the asset. Here are some examples. Again, just reminding you that you have to have roof replacement, building painting, pavement and resurfacing, any item that's greater than $10,000 as a reserve item. If you don't set aside money in your reserves, more likely than not, you're going to need to levy a special assessment, probably a hefty one against your membership when a time does come for that replacement or repair. Waiving or reducing reserves. The board adopts the budget with fully funded reserves. Then the board can present to the membership the opportunity to waive or reduce reserves. The members meeting at which a quorum is attained, which typically follows, again, the budget adoption and usually coincides with the annual meeting, as we spoke about before. The unit owners vote in person or by limited proxy to waive or reduce reserves. To pass, a majority of a quorum voting in favor is required. If the board decides to present to the members the right to waive or reduce reserves, then it should send out both budgets. So you'll send out your budget that has fully funded reserves, and you will send out your budget with the waived or reduced reserves, depending upon what option the board is presenting to its membership. If at the meeting no waiver or reduction in reserves is achieved or quorum is unattained, then the reserves, as indicated with the budget with fully adopted reserves, goes into effect. Reserve funds and any interest accruing on those reserve funds have to remain in the reserve account until spent on its designated purpose. They can only be used for the authorized reserve expenditure unless their use for another purpose is approved in advance by a majority of all unit owners at a membership meeting. You can also pool reserves. So let's say your roof replacement, your pavement resurfacing, you want to put those together. Reserve accounts can be pooled, meaning that an association may have one reserve account to pay for multiple categories of reserves instead of separate accounts for each reserve item. You do need, again, that majority of all owners to approve at a duly noticed membership meeting in order to pool those reserves. Now, remember I said that if you're not going to have reserves fully funded, you're likely going to need a special assessment at the time when that reserve item gets to its useful life. You need to warn your membership about that. And the statute has a certain disclosure you have to put onto your limited proxy as that warning. Limited proxies are relating to waiving or reducing the funding of reserves or using existing reserve funds for purposes other than for which the reserves were intended must contain the following statement in capitalized bold letters, font size larger than any other font size on the page. Waiving of reserves in whole or in part, or allowing alternative uses of existing reserves may result in unit owner liability for payment of unanticipated special assessments regarding those items. So you need to disclose that fact on the limited proxy. We also include on the ballot as well. Financial reporting and providing the membership with a copy. Within 90 days after the end of the fiscal year, the association must prepare or contact their CPA to prepare a financial report for the preceding fiscal year. Within 21 days after the final financial report is complete, the association must mail or hand deliver to each unit owner a copy of that financial report or notice that a copy can be provided and must be provided within 5 days upon receipt of written request from the owner. That copy or that notice has to be sent not later than 120 days after the end of the fiscal year for which it was prepared. A unit owner can provide written notice to the division. Well, I'm not going to go through this slide word for word, but just know that if you fail to provide the copy of the financial report or that written notice, they things that the owner can do with the division to force it on you. And that speaks to this particular procedure. 718.71, this is really part of our Distressed Condominium Relief Act. An association must provide an annual report to the DBPR. That's the Department of Business and Professional Regulation. It's the grand poobah under which the Division of Florida Condominiums, Timeshares, and Mobile Homes exists. An association must provide an annual report to the DBPR containing the names of all the financial institutions with which it maintains accounts, and a copy of such report may be obtained from the DBPR upon written request of any association member. This slide sets forth the type of financial report that you need to provide or prepare based upon your total annual revenues. If you have annual revenues greater than 500,000, you need to prepare audited financial statements, and it goes down from there. Reviewed financial statements or compiled financial statements. Anything less than that, it's a report of cash receipts and expenditures under that $150,000 mark. Now you can change the level of financial reporting. The board can do it if they move to a greater level of financial reporting. If you want to lower the level of financial reporting, you have to obtain the membership of a majority of the voting interest present in the properly called meeting of the association. And it gives you, the slide gives you a little description of how those levels of financial reporting get lowered. The meeting and approval must occur before the end of the fiscal year and is effective only for that fiscal year in which the vote is taken. Can also be done for the following fiscal year. Transfer fees. So generally speaking, transfer fees are deemed to violate the public policy of the state of Florida as an unreasonable restraint against alienation of real property. But there are certain exceptions in this particular statute, and that's where any fee that's going to be in your declaration or covenant law applicable to that association. And for condominium associations, we have a particular statute which governs transfer fees. That's 718.112 sub 2 sub I. The condominium association cannot charge a fee, another typo, a fee in connection with a sale, mortgage, lease, sublease, or other transfer of a unit unless the association is required to approve such transfer, and a fee for such approval is provided for in the declaration, articles, or bylaws. So check your governing documents to see if the requisite authorities are there. The fee cannot exceed $150 per application, per applicant, other than husband, wife, or parent dependent child, which are considered one applicant. This used to be $100. It was just changed to $150. Check your governing documents to see if maybe you've got some Kaufman language in there, so that you can use the increased value. Every 5 years, the division is supposed to or can increase the amount according to some consumer price index that's set forth in that statute. If the lease or sublease is a renewal of a lease or a sublease with the same lessee or sublessee, you cannot make that charge. You can, in addition to the transfer fee, require a security deposit not to exceed the equivalent of 1 month's rent held in escrow to protect against damages to the common elements or association property. If you're going to collect this security deposit, you need to follow the procedures for handling security deposits that's set forth in Part 2 of Chapter 83, which is with regard to residential tenancies. Estoppel certificates. This was a statute that came into play maybe a few years ago now. Within 10 business days of receiving a written or electronic request for an estoppel certificate from an owner, a mortgagee, or either of their designees, the association must issue an estoppel certificate. You have to designate on your website, if you're required to have a website, a person or entity with a street or email address for the receipt of estoppel certificate requests, have to be completed by a board member, authorized agent, or authorized representative of the association. It could include the management company as well. must be provided by hand delivery, regular mail, or email on the date of issuance, and have to be signed by an officer or authorized agent of the association. Now, the statute sets forth the form in which the estoppel certificate must be provided and the information that has to be set forth in that certificate. So there are a few different categories. The first being general information, date of issuance, name of the owner, unit designation, address, parking garage space, attorney's name, if it's been turned over to collections. The fee for preparation, which we'll talk about a little bit later, and the name of the requesting party. And there's some assessment information there, the amount of regular periodic assessments against the unit, how frequent it is, monthly, quarterly, what have you, the date that the assessment is paid through, itemized list of the assessments, any additional assessments, special assessments that are scheduled to become due, and some other information, if there's capital contribution fee, which in a condominium association, you're really not going to have. Transfer fee, again, that's that $150 if you have the authority to approve transfers and have the authority to charge the fee. Whether or not there's board approval for transfers, right of first refusal, all that's going to be set forth in your governing documents and needs to be provided in your estoppel certificate. So what can we charge for these estoppel certificates? Well, you can charge a reasonable fee, not exceeding $250, if on the date the certificate is issued, there are no delinquent amounts. If there's a delinquency, you can charge an additional $150. And if they want the certificate expedited within 3 business days after the request, you can add another $100 fee. In order to charge the estoppel fee, the authority to do so must be established by written resolution adopted by the board or provided by a written management, bookkeeping, or maintenance contract. If the association fails to deliver the estoppel certificate within 10 days of receipt of the request, you cannot charge a fee. There's also a way in which you can get the fee. The person who paid the fee can get the fee back. We'll talk about that on the next slide. Estoppel certificates delivered by hand or by email are effective for 30 days. Estoppel certificates delivered by mail are effective for 35 days. If additional information or mistake becomes known to the association, you issue an amended estoppel certificate, and once it's been issued, it becomes effective for either that 30-day or 35-day period. You cannot charge a fee. I don't know if I said that already. An association waives the right to collect any monies owed in excess of the amount specified in the estoppel certificate from any person who in good faith relies upon the estoppel certificate and from that person's successors or signs. So it's very important not to get the numbers wrong. Some reimbursement of the estoppel certificates. If the certificate is requested, you issue the certificate, the closing doesn't happen. If within 30 days from that closing, you get a written request for a refund, you have to issue the refund, but you can then assess the owner for the amount of that fee. That's what this slide is saying. You cannot waive the right to reimbursement or modify the right to reimbursement by contract or agreement. And the prevailing party in any action brought to enforce a right of reimbursement is awarded damages and all applicable attorney's fees and costs. Condominium associations or their authorized agent can charge a fee to a prospective purchaser or lienor, what have you, for providing good faith responses to requests for information, so long as the fee does not exceed $150 plus the reasonable cost of photocopying and any attorney's fees incurred by the association in connection with the response. Typically, this is done by a prospective lender who wants to know if there's any litigation liability, prior to issuing a loan on the purchase of a unit. The condominium association and its authorized agent are not liable for providing such information in good faith. If you have this magic language, the responses herein are made in good faith and to the best of my ability as to their accuracy. Some other purchase and sale documents. There's the condo question and answer sheet. You have to update it annually, must provide it to prospective purchasers, and the seller has the duty to provide the buyer notice of all hidden defects. Unit owner disclosure prior to sale. Each prospective purchaser who has entered into a contract for the purchase of the unit has to provide a copy of the declaration, articles, bylaws, rules of the association, the financial information, that's going to be your like financial report, the frequently asked question and answer sheet, which was referenced in the slide previous, and this division created governance of condominium association form. That's a fairly recent creation. It provides some generalized information of the responsibilities of the board, of the owners regarding maintenance, abiding by their governing documents, providing advance notice of board and membership meetings. It's like a very watered down Reader's Digest of this particular presentation. And it is available online through the division's website. Some more information about what's contained in that governance form. Conflict of interest. So in this past legislative session, the legislature removed 718.112.2p, which prohibited an association from employing or contracting with any service provider that is owned or operated by a board member, or with any person who has a financial relationship with a board member or officer or relative within the third degree of consanguinity by blood or marriage of a board member or officer. So they removed that outright prohibition and really now rely in favor of the conflict of interest disclosure and voting requirements. So directors and officers and the relatives of such directors and officers must disclose to the board any activity that can reasonably be construed as a conflict of interest. A rebuttable presumption is created if any of these factors exist. One, a director or an officer or relative of a director or of an officer enters into a contract for goods or services with the association, or a director or officer or a relative of that director or officer holds an interest in a corporation, LLC, partnership, LLP, or other business entity that conducts business with the association or proposes to enter into a contract or other transaction with the association. If the director, officer, or that relative of director or officer proposes to engage in activity that's conflict of interest, that proposed activity has to be listed on and on all contracts, transactional documents related to that proposed activity must be attached to the meeting agenda at which that activity is going to be considered by the board. The association must comply with the disclosure requirements set forth in the Not-for-Profit Act. And those disclosure requirements have to be set forth in the minutes of the meeting. The approval of the contract or other transaction requires the affirmative vote of 2/3 of all other directors present. So the person who has a conflict or potential conflict of interest must not vote. In fact, they're not going to be in the room. If the board votes against the proposed activity, the director, officer, or relative must notify the board in writing of his or her intention not to pursue the proposed activity or to withdraw from office. At the next regular or special meeting of the members, the existence of the contract or other transaction must be disclosed to the members. If the board finds that an officer or director has violated these provisions, again, we talked about this earlier, the director or officer is deemed removed from office and then the vacancy filled by the board. The director, officer, or relative who is a party to or has an interest in an activity that is a possible conflict of interest, they can attend the meeting, they can give a presentation to the meeting, but once it's time to vote, to have a discussion, they have to leave the meeting. And the director or officer who is a party to or has an interest in the activity must recuse themselves from the vote. A contract entered into between a director or an officer or a relative of that director or officer and the association that has not been properly disclosed as a conflict of interest or potential conflict of interest is voidable and terminates upon the filing of a written notice terminating the contract within the board of directors, which contains the consent of at least 20% of the voting interests of the association. A little bit about obtaining or taking meeting minutes. You always have to take meeting minutes, board meetings, membership meetings. Minutes do not need to be verbatim records. You don't have to put like Sally said this and then Johnny said this. You can just give an example or just a general statement of what the discussion was. As of July 1st, 2018, meeting minutes must be permanently maintained from the inception of the association. We'll talk more about official records later in the presentation. There's a small example of what minutes can look like. Again, do not have to be verbatim records. Outgoing board and committee members must return all effectual records, any property of the association in their possession or control, to the incoming board or committee member within 5 days after the new committee member or board member is elected or appointed. Those outgoing board and committee members who willfully and knowingly fail to return the records and property are subject to penalties imposed by the division. A little bit about access to units. The association has the irrevocable right to access each unit during reasonable hours when necessary for the maintenance, repair, or replacement of any common elements or of any portion of the unit to be maintained by the association pursuant to the declaration, or is necessary to prevent damage to the common elements or to a unit. Statute doesn't say that you have to provide notice. It's always a good idea to provide notice. Your documents may say provide notice. And inherent with the irrevocable right to access the unit is the right to maintain a key of the association that has to be safely guarded. If you have an abandoned unit within your property, the association can enter the abandoned unit to inspect the unit, inspect the common elements, make any repairs, turn on utilities, otherwise maintain and protect the unit and the adjoining common elements. When is a unit considered abandoned? When the unit is under foreclosure and no tenant appears to have lived at the unit for 4 consecutive weeks without prior written notice to the condominium association, or no tenant appears to have lived at the unit for 2 consecutive months without prior written notice to the association, and the association is unable to contact the owner or determine the owner's whereabouts after reasonable efforts. Prior to entering the abandoned unit, the association must send 2 days notice of its intent to enter the unit at the unit owner's last known address, and any costs that are associated with the association's maintenance or repairs within that abandoned unit are accessible against the unit. The association can request the court appoint a receiver to handle the affairs of the unit, and then any rent that is collected is credited against the monies due to the association and the receiver. Process servers, you got to let them in unannounced. That's all. Rules and regulations. Rules and regulations must bear relationships to the health, safety, and welfare of the association, its unit owners, or the building and its improvements. Must be reasonable. You can't infringe on rights created in the declaration, articles, and bylaws. And you can't infringe on rights that are reasonably inferable from the declaration. If the proposed rule affects a unit's use prior to board adoption, the association must provide 14 days notice to the unit owners. We discussed this earlier. And the notice must be mailed and posted in a conspicuous place in the community. Otherwise, normal board meeting is 48 hours. Material alterations, what are they? Well, seemingly everything based off of this definition that was set forth in a seminal case for condominium associations. As applied to buildings, the term material alteration or addition means to palpably or perceptively vary or change the form, shape, elements, or specifications of a building from its original design or plan or existing condition in such a manner as to appreciably affect or influence its function, use, or appearance. It's a long definition. Because the definition is so long, we have a list of few examples here of what constitute material alterations. These are from division arbitration decisions, the subdivision of a room previously used for social gatherings and to do separate rooms in order to construct a board meeting room, conversion of a game room into an office for the manager, conversion of the manager's office into a locked storage room, construction of a stage in a recreation hall, the construction of a walkway between buildings to connect to the swimming area. There are lots of things, lots of improvements and alterations that would be deemed a material alteration. If a condominium's declaration as originally recorded or as amended does not specify the procedure for approval of material alterations or substantial additions, you need to obtain 75% approval of the total voting interest of the association before the alteration or additions are commenced. Again, there must be an exception to this particular rule, and there is. It's known as the necessary maintenance rule. Florida case law has created this exception where alterations and improvements by the association are shown to be necessary to maintain or to protect the common elements of association property. There is this particular line of cases that follow this one seminal case called Tiffany Plaza. In this case, they had a high-rise condominium on the water, was being threatened by rising tides, and the board wanted to put in a rock revetment wall to keep the association from getting flooded. The membership wouldn't approve the special assessment to do it. The board did it anyway. The association's members, a couple of them sued, and the judge said, "What, you crazy? No. The association had to do what it needed to do in order to protect the units and the common elements." And from that flowed more decisions about boards taking action without membership approval in order to protect the units and the common elements, and to conduct necessary maintenance and repairs to the condominium property. A division arbitrator has held that a change from acoustical ceiling tile to drywall as a ceiling material was reasonably necessary and a more durable, cost-effective material. In reaching this conclusion, the arbitrator noted that where an alteration or addition is necessary to maintain or preserve the common elements, it was exempt from the requirement of unit owner approval. And there are times when the board may be able to take advantage of advancements in technology when making certain repairs or replacements within the condominium property. Again, when the board is contemplating not obtaining membership approval or membership approval is required for material alteration or special assessment with regard to that particular alteration, contact your association's attorney so that they can provide you with additional guidance as to what documentation you may need should there be a cantankerous owner who wants to challenge. A unit owner may display one portable removable flag. There are other flags which are exempt from material alteration approval requirements. This came down this particular year about natural gas fuel stations, which was added to the existing exemptions for electric vehicle charging stations. Certain telecommunication equipment must be allowed, and there are other exceptions. For example, a mezuzah. Unit owners who are of the Jewish faith can put a mezuzah on their door frame without it constituting a material alteration to the common elements. Hurricane protection. The board must adopt hurricane protection specifications. Upon approval of majority of the voting interest, the association can install hurricane shutters, impact glass, other types of code compliant hurricane protection. A vote of the owners is not required if the maintenance, repair, or replacement of hurricane shutters, impact glass, or other types of code compliant hurricane protection are the responsibility of the association pursuant to the declaration. The board can operate hurricane protection without permission of the unit owners only if the operation is necessary to preserve and protect the condominium property and the association property. Notwithstanding any other provision in the condominium documents, the board may not refuse to approve the installation or replacement of hurricane protection by a unit owner conforming to those specifications adopted by the board. Leasing. Okay, so if the association is authorized by the declaration or bylaws to approve or disapprove a proposed lease of a unit, the grounds for disapproval may include, without limitation, a unit owner being delinquent in the payment of an assessment at the time the approval is sought. New leasing restrictions regarding prohibiting unit owners from renting their units, altering the duration of the rental term, or specifying or limiting the number of times unit owners are entitled to rent their units during a specific period must be in the declaration of condominium and apply only to those unit owners who vote in favor of the new leasing restrictions if they are in fact approved as amendments to the declaration. If the owner does not vote in favor of those new leasing restrictions and they pass, then the new leasing restrictions don't apply to that particular owner. So it's important to maintain stringent records, voting records, when you guys are going to be presenting and approving amendments to the declaration regarding these specific leasing restrictions. An association and its officers, directors, employees, agents, they cannot use a debit card issued in the name of the association or bill directly to the association for any association expense. use of a debit card issued in the name of the association, or billed directly to the association for any expense that's not a lawful obligation of the association can be prosecuted as credit card fraud. An association may not hire an attorney who represents the management company of the association. And that is the end of our little smorgasbord. So now let's get back to some of the larger topics. As we spoke about earlier, use right suspensions, voting suspensions, and findings. When we're talking about committees, we're going to delve into some of the particulars with regard to these fines and suspensions. Fines and use right suspensions for non-monetary obligations. So this is for any violation of your governing documents. The association has the authority to fine, suspend use rights of unit owners or their occupants, licensees, or invitees for failing to comply with the governing documents. There is a set procedure that needs to be followed, set forth in the statutes. A fine or use right suspension may not be levied unless, first, the board levies the fine or use right suspension and provides the owner with written notice of the violation and an opportunity to attend a hearing on the violation not sooner than 14 days from the date of the notice. So board levies, they send out that 14-day notice. Then you have your committee hearing. The hearing must be held before a committee of which are comprised of people who are not officers, directors, or employees of the association, or the spouse, parent, child, brother, or sister of a director, officer, or employee. And the role of the committee is limited to confirming or rejecting the fine. If they change the fine, they say, oh, you know what, board, that's too much. We're not going to go with that. We're going to go with $20 instead of $75. That's considered a rejection. So you can either say yay or nay. If they say nay, then you cannot impose the fine or the use right suspension. A fine cannot exceed $100 per violation and may be levied on the basis of each day of a continuing violation with a single notice and opportunity for a hearing. Fines cannot exceed $1,000 in the aggregate, and fines cannot become a lien against the unit. Use right suspensions for failing to pay monetary obligations greater than 90 days. So use right suspensions we can do for both violations of the governing documents and for failing to pay monetary obligations greater than 90 days. Fining we can only do for violations of the governing documents, and what we'll talk about next is voting right suspension. That's only going to be applicable for failing to pay monetary obligations greater than 90 days and greater than $1,000. So use right suspensions for failing to pay monetary obligations greater than 90 days. This can be done through board action. The association may suspend the right of the unit owner or the unit's occupants, licensee, or invitee to use common elements, common facilities, or any other association property if the owner is more than 90 days delinquent in any monetary obligation due to the association. That's more than 90 days. That's not on the 90th day, that's on the 91st day. The use right suspension is effective until the monetary obligation is paid in full. You can contemplate doing it globally. Contact your association's attorney if that's something that you may want to do, but you may not want to do it. In order for the use right suspension to take effect, the board must notice the unit owner, occupant, licensee, or invitee of the suspension after it's been approved by the board. There is one caveat to use right suspensions. While you can suspend the right of the unit owner or the unit's occupant, licensee, or invitee to use common elements, common facilities, or any other association property, the suspension does not apply to limited common elements intended to be used only by that unit, common elements needed to access the unit, utility services provided to the unit, parking spaces, or elevators. The suspension applies to a member and when appropriate, the member's tenants, guests, or invitees, even if delinquency or failure that resulted in the suspension arose from less than all of the multiple units owned by a member. So if I own 10 units and I'm failing in the one and I get assessed a fine, it's assessed a use right suspension for the one, it applies to all. Voting suspension. So there was a little bit of change in this this year pursuant to case law. Voting rights suspensions, again, you can only impose for failing to pay monetary obligations greater than 90 days. This is only through board action, again, greater than 90 days, and the delinquency has to be greater than $1,000. The authority to suspend voting rights as amended into section 713-303 was effective July 1st, 2011. There was a recent case, it's De Soleil South Beach. The citation is there if you so choose to look it up. It provides that for those declarations recorded prior to that effective date of the amendment, again, that's July 1st, 2011, the authority to suspend voting rights must be in the association's declaration, or the declaration has to provide that Kaufman language in order to have the authority to suspend voting rights. Kaufman, again, being that as amended from time to time when we're talking about statutory reference to Chapter 718. If authorized by statute or declaration, the association can suspend voting rights if the unit owner is greater than 90 days delinquent in any monetary obligation due to the association, again, greater than $1,000. It's effective until the monetary obligations are paid in full to the association. You have to provide written notice of the suspension to the owner by mail or hand delivery, and proof of the obligation must be provided to the owner 30 days before the suspension takes effect. You want to be careful what you wish for, though, with these voting rights suspensions. The suspension of voting rights may not be counted toward the total number of voting interests for any purpose, including to establish a quorum or to approve an action, including elections. So if you have an owner who's delinquent and you're thinking about suspending voting rights, well, maybe you don't want to do that if that person is otherwise active with the association's business. Non-binding arbitration, or new this year, pre-suit mediation. As of July 1st, 2021, before the institution of court litigation, a party to a dispute, which is defined on the next slide, can either petition the division for non-binding arbitration, which has been in existence for quite some time with regard to condominium associations, or initiate pre-suit mediation in accordance with section 720.311, and that's in our Homeowners Association Act. However, election and recall disputes are not eligible for mediation, and such disputes must be arbitrated by the division or filed in the court of competent jurisdiction. A dispute is any disagreement between one or more parties that involves the authority of the board to require any owner to take any action or not to take action regarding that owner's unit or the appurtenances to the unit, or to alter or add to the common area or common elements. The failure of the association to properly conduct elections, give adequate notice of meetings, properly conduct meetings, allow inspection of the books and records, and also the plan of termination, which again, we'll be hearing toward the end of this presentation. Arbitration or pre-suit mediation disputes do not apply to title to any unit or common element, interpretation or enforcement of any warranty, the levy of a fee or assessment, eviction, breaches of fiduciary duty, claims for damages to the unit based on the failure of the association to maintain the common elements of condominium property. Those are all things that you would have to go to court for. A pre-suit mediation procedure, this is what's set forth in your Homeowners Association Act, that particular statute that I quoted before, 720.311. Before being able to file a lawsuit, the aggrieved party must serve written notice, written demand on the other party to participate in pre-suit mediation. There is a form that's set forth in that particular statute about how it needs to be set up, and there's a sheet that gets signed and returned for the selection of the mediator, because you have to provide 5 different mediator names and some information regarding those mediators in that particular demand. The parties are required to share the cost of the pre-suit mediation equally, including the mediator's fee, and the mediator may require advance payment of their fees. Once the respondent has received that demand to participate in pre-suit mediation, they have 20 days to send back their selection of the mediator. An impasse entitles the aggrieved party to proceed in court against the responding party without further notice and to seek an award of attorney's fees and costs associated with the mediation. An impasse occurs when a party fails to respond within that 20-day period, fails to agree to at least one of the mediators that was suggested, again, that list of 5 mediators, fails to make payment of the mediator fee within the time established by the mediator, or fails to appear at the scheduled mediation. So that was your option for pre-suit mediation. Again, that's new this year. Going back to our tried and true non-binding arbitration, why is it called non-binding arbitration? Either party has 30 days to appeal the decision, after which the decision becomes binding. To enforce the decision, you have to go to circuit court. To appeal the decision, you have to go to circuit court. And yes, there are prevailing party attorney's fees, but you're never going to be made whole. You can go to mediation through arbitration, and usually once you do, the arbitrator is not going to let you back into arbitration, and you'll be forced to go to circuit court if the matter doesn't get resolved at mediation. Official records. So there are a number of records that are listed in the Florida statutes that must be maintained by the association. Here, and this provides you with that list. What you see in green was what was made a requirement to maintain permanently back in, I think, 2017. Copy of the plans, permits, warranties, and other items provided by the developer. Your recorded declaration and bylaws, any of those amendments to those documents, certified copy of the articles of incorporation and any amendments to those documents, your current rules of the association, and your meeting minutes. Those you need to maintain permanently from the inception of the association. Current roster of all unit owners and their mailing address, unit identifications, voting certificates if you have those, and if known, telephone numbers and email addresses and facsimile numbers of unit owners consenting to receive notice by electronic transmission. All current insurance policy of the association and condominium operated by the association. Copy of your management agreement, bills of sale or transfer, accounting records, ballots, sign-in sheets. Again, we talked about that earlier. Those have to be maintained for a year. Rental records of the association, copy of the question and answer sheet that has to be updated annually. All other written records of the association not specified above. A copy of the inspection report and bids for work performed, material, equipment, or services have to be maintained for at least a year after receipt of those bids. Now, there are certain records that are not going to be accessible to unit owners. These include records protected by the attorney-client privilege or work product privilege, information obtained by the association in connection with the approval of the sale, lease, or other transfer of a unit, medical records of unit owners, personnel records, electronic security measures, and software operating systems used by the association for manipulation of data, social security numbers, driver's license numbers, and contact information other than as provided to fulfill the association's notice requirements. The unit owners can consent to the disclosure of otherwise confidential information. That consent must be received in writing, and the association is not liable for the inadvertent disclosure of information that's not accessible to unit owners if the information is included in an official record of the association and is voluntarily provided by an owner and not requested by the association. This gives you a little description of what the attorney-client privilege is. Correspondence from the association law remains privileged unless the board votes to waive the privilege. This is a privilege that's held by the association. It's not a privilege that we have and can waive. The association is not responsible, again, for the inadvertent disclosure, and they're not responsible for the use or misuse of information provided to an association member or their authorized representative pursuant to the in complying with the act, unless the association has an affirmative duty not to disclose such information. So once you receive a written request to access the official records of the association, you have to provide that access within 10 working days. The official records are open to inspection by any member or their authorized representative at all reasonable times, and the association cannot require that a member demonstrate any purpose or state any reason for the inspection. A renter of a unit has the right to inspect and copy the association's declaration, bylaws, and rules. The right to inspect includes the right to make copies or obtain copies at the reasonable expense, if any, of the association member. The association member can also, take pictures of it with their phone or bring a copy machine and not be charged for that. The association may adopt reasonable rules regarding the frequency, time, location, notice, and manner of record inspections and copying, and absolutely should, just like with membership statements and video recording, audio recordings of meetings. The failure of an association to provide the records within 10 working days creates a rebuttable presumption that the association willfully failed to comply with the official records request. A unit owner who's denied access is entitled to actual damages or minimum damages for the association's willful failure to comply. The minimum damages are $50 a day, up to 10 days, calculated from the 11th working day after receipt of the written request. The failure to permit inspection of the records entitles any person prevailing in an enforcement action to recover reasonable attorney's fees from the person in control of the records who directly or indirectly knowingly denied access to the records for any inspection. Again, this is a fee that's collected from the person, not necessarily from the association. Unit owner directories. A lot of associations have these. An association may publish and distribute to unit owners a directory providing all the telephone numbers associated with an owner. However, the owner can exclude their telephone number. This directory also includes the owner's name and their address. Again, an owner can provide written consent to the disclosure of other information, and the association is not liable for the inadvertent disclosure of information that is protected under the Act if it's included in an official record and voluntarily provided, not requested by the association. Email addresses and facsimile numbers are not accessible to unit owners unless they're provided to fulfill the association's notice requirements, or the unit owner provides written consent to the disclosure again. And there's no penalty for inadvertent disclosure of the information if it's not requested by the association and voluntarily provided by the unit owner. Are emails official records that must be provided in response to an official records request? Generally speaking, from board member to board member, no. If you're using the association's computer, maybe. Board member to manager, yes. These are from decisions of the division. Again, DBPR, that's the parent of the division. Emails between a board member and a manager constitute part of the official records subject to inspection by the requesting member.
Danielle, does that include texting? That was a question that was in the Q&A there.
Texting has not been addressed by the division, to my knowledge.
Okay.
That's a super interesting question that maybe the law has not adjusted to the 21st century in that regard. I don't know. It is, I guess it would be written, but if it's on your personal device, probably not. But if it's with the manager, maybe so.
Yeah, if it's with the manager, that makes sense. Okay, thank you.
Because I recall that one particular decision of the division saying, if it's your personal email used on your personal computer, it's likely not going to be included within the association's official records. So if it's on your phone, your personal phone, board member to board member, likely not going to be mandated to be part of the association's official records, but board member to manager, likely so.
Yeah, sorry for the interruption. I was staring at that question right as you were talking about this.
No problem. No problem. Feel free. So moving on to websites. If you have an association, if your association has 150 or more units, you've likely already complied with this requirement to have a website because you were required to have one by January 1st of 2019. The division should have notified you about needing to comply with this requirement. Your website has to be an independent website or web portal wholly owned and operated by the association, or a website or web portal operated by a third-party provider with whom the association owns, leases, rents, or otherwise obtains the right to operate the website. There are certain website requirements. You have to have a portion that is protected by a username and password for unit owner access only. That's what this is saying here. You have to post certain governing documents or certain official records of the association on that website, the recorded declaration, bylaws, all amendments to them, the articles of incorporation, all amendments to those, rules of the association, management agreements, other contracts to which the association is a party, summaries of bids or materials, equipment or services maintained on the website for a year, annual budget, proposed budget, financial report or any proposed financial report, certification of each director. That means that little form that you're going to get after. If you have a website requirement, you need to post that document on your association's website. Current copy of the following documents must be posted on the website. Then some more documents here. Any contract or document regarding conflict of interest that we talked about earlier, notice of board meetings, their agenda, other documents required for the meeting must be posted no later than the required notice. So if it's a 14-day, 48 hours. The association must ensure that the information and records that are not accessible to unit owners are not posted on the association's website. If protected information or information restricted from unit owner access is included in documents that are required to be posted, you have to make sure that that information is redacted from the record before you post it online. And here's a new website requirement. The association that is required to post official records on its website can make the documents available through an application downloaded on their mobile device, more commonly referred to as an app. You know, there's an app for that. Contracts and bids. Certain contracts have to be in writing. A contract that's not fully performed within 1 year for the purchase, lease, or renting of materials or equipment to be used by the association in accomplishing its purposes, and all contracts for the provision of services. While this requirement is here for only these particular contracts, very smart to obtain written agreements for everything. If a contract or the purchase, lease, or renting of materials or equipment for the provision of services require payments by the association on behalf of any condominium operated by the association in the aggregate that exceeds 5% of the total annual budget of the association, which includes reserves in that calculation, the association has to obtain competitive bids for the materials, equipment, or services. Now, we always hear like, oh, I have to get 3 bids. I have to get 3 bids. I'm not sure where this 3 bids is coming from because the statute doesn't require that you obtain 3 bids. 2 bids is fine. Get as many bids as you want, but there's no statutory requirement for that. The association is not required to accept the lowest bid. However, there are exceptions to the 5% rule. You don't need to bid for contracts with people like me, attorneys, accountants, architects, your management, if the contract is over 3 years, something like that, I think. No, community association manager is listed there. If the business entity with which the association wants to enter into a contract with, if the only source of supply within the county serving the association, and associations with less than 10 units can opt out of the bidding requirements upon 2/3 vote of the unit owners. This particular slide is with regard to turnover, like recently turned over community or condominium associations. After turnover or after 75% of the units are sold, 75% of the unit owners can vote to cancel a contract that was entered into by the developer controlled association. Assessments, collections, foreclosures. This is a new item that was added by the legislature, this invoice delivery method, and there we'll talk about another notice that was added by the 2021 legislative session next. You're really going to want to reach out to your association's attorney to determine compliance, particularly with the notice of late assessment, because it can affect your ability to collect and to obtain attorney's fees. So notice of delivery method, if an association sends out, an invoice for assessments or a statement of account, they must be delivered to the owner by first class US mail or by email. Before changing the delivery method, the association has to mail written notice of the change to each owner at least 30 days before the association sends the invoice or statement by the new delivery method. The notice has to be sent by first class US mail to the owner at their last address reflected in the association records. And if it's not the unit, then you also have to send it to the unit. An owner must affirmatively acknowledge electronically or in writing his or her understanding that the association will change its delivery method before the association can change the delivery method. And the affirmative acknowledgement must be maintained among the association's official records, but it's not subject to inspection and copying. Okay, so this is that notice of late assessment. The association may not require the payment of attorney's fees related to a past due assessment without first delivering a written notice of late assessment to the owner, which specifies the amount, excuse me, the amount owed to the association and provides the owner 30 days to pay the amount owed without the assessment of attorney's fees. Okay, so there is a notice form for this. It's set forth in the statute that's cited right there. Make sure that whatever notice you guys are using are in substantial compliance with what's provided by the statute. The notice of late assessment must be sent by first-class U.S. mail to the owner at his or her last address, as reflected in the official records of the association, and if not to the unit, if that's not the unit address, you have to send it to the unit. A rebuttable presumption that the association mailed a notice in accordance with the statute is established if a board member, officer, or agent of the association or their LCAM provides a sworn affidavit attesting to the mailing. Assessments which are not paid when due can accrue interest at the rate provided in the declaration from the due date until paid. If there's not a rate in the declaration, the rate cannot exceed 18% per year. Anything beyond 18% is considered usurious. If provided by the declaration or the bylaws, the association may, in addition to interest, charge an administrative late fee up to the greater of $25 or 5% of the installment. Danger Will Robinson Danger do not charge interest on interest or late fees. The association is also entitled to collect attorney's fees and costs incurred in collection of any delinquent assessments. Again, red alert for the notice of late assessment, that new 30-day notice. Any payment received by an association must be applied first to any interest accrued by the association, then to any administrative late fee, then you pay your attorney, then you get to the delinquent assessment. So you don't actually get to pay that primary delinquency until all those other payments have been satisfied. Restrictive endorsements or designations or instructions placed on or accompanying payment with regard to the order of payment, they're meaningless. An application of payments is applicable regardless of any purported accord and satisfaction or any restrictive endorsement, designation, or instruction placed or accompanying the payment. First mortgagee assessment liability, which some of you may otherwise know as the safe harbor provision. The liability of a first mortgagee or a successor assignee who acquires title to the unit by foreclosure or by deed in lieu of foreclosure is protected from assessment liability and is only responsible for the lesser of the 12 months back assessments or 1% of the original mortgage debt. Limitations on the first mortgagee assessment liability apply only if they joined the association as a defendant in the foreclosure action. Sub-association versus master association lien priority. The association that is the sub, if there are some due and owing assessments to the master, basically once the sub forecloses on the unit, they're not going to owe any money to the master association. When this statute was created, it said this provision is intended to clarify existing law. However, there was no existing law at the time. That's what the legislature does sometimes. They say something is a matter of public policy or to clarify existing law. And that's a couple of the ways in which you can get some retroactive impairment of substantive rights in that legislative I said so approach. Third-party bidder liability. A third-party bidder on a foreclosure property has joint and several liability for any past due assessment, but the condominium association itself is not considered a previous owner. So the unit owner who acquires the unit after the association is not jointly and severally liable to the condominium association for the unpaid assessments that came due while the condominium association owned the unit. So like the assessments that accrue while the association owns the unit are basically just gone. However, the unit owner remains jointly and severally liable for the unpaid assessments of the former owners. The next couple of slides discuss ways in which the association can speed up their lender foreclosure or their own assessment foreclosure actions. This is really something for your association's attorney to know, but you can look at this information if you would like. What's important on this order to show cause, and that it's only applicable to non-owner occupied units. Okay, so if you have a unit that is occupied by the owner under foreclosure, you can't use this order to show cause. Foreclosed unit purchasing prohibition: a board member, manager, or management company cannot purchase a unit at a foreclosure sale resulting from the association's foreclosure of its lien for unpaid assessments, or take title by deed in lieu of foreclosure. If a unit owner becomes delinquent in assessments to the association and the unit is leased, there is a manner in which the association can obtain the rental payments directly from the tenant to satisfy the monetary obligations of the owner. The manner is set forth in this particular statute, and there is also the notice language is set forth in this statute. I'm going to skip ahead a little bit on this tenant obligation for monetary obligations of the owner, only because we are reaching the time, and I do want to get to some of the other topics at the end of this presentation.
Yeah, hang tight, everybody, because we have on the advertised time about 8 minutes to go. Still to come is the assistance animals and pets issue. And in a couple of minutes, once we get to the assistance animals issue, we're going to we will then place the link for the evaluation into the chat area. So start getting familiar with where the chat area is. And you could also, you'll be able to print your own certificates, and the chat, the evaluation page will also have a link at the top to download the slides. Back to you.
Okay, thanks, Jeff. So receivers and receivership. A receiver is basically a disinterested third party who's appointed by the court to handle matters, usually for a unit that is being rented. There are certain statutory powers that are given to a receiver. They also have equitable powers, which was established by this case on this particular slide. Receiver needs to get paid, usually gets paid out of the rents that are received from that particular unit. Receiver cannot exercise voting rights of the unit owner whose unit is placed in a receivership. Insurance. Very important that the association board exercise its best efforts to obtain and maintain adequate insurance to protect the association property, and the common elements. You can also get insurance to protect from flood, D&O coverage. Adequate property insurance, regardless of the requirement in the declaration or for coverage by the association for full insurable value, must be based on replacement value of the property to be insured. The replacement cost has to be determined at least once every 36 months. Any portion of the condominium property that must be insured by the association against property loss, which is damaged by an insurable event, must be reconstructed, repaired, replaced as necessary by the association as a common expense. If there's any other damage that's not an insurable event, you're going to look to your governing documents to determine what the maintenance, repair, and replacement obligations are. This particular slide is saying that you need to check your insurance policy to make sure that it's specific with regard to your covered perils. If it's making general reference to the statute for the coverage, go back to your insurance carrier and get them to put the details in there. Insurance fidelity bonds. The association must purchase and maintain adequate insurance or fidelity bonding for all persons who control or disperse funds of the association. Has to cover the maximum funds that will be in the custody of the association or its management agent at any one time. These people include individuals authorized to sign checks, president, secretary, and treasurer of the association. And the association is going to bear the costs of that insurance, fidelity insurance, or bonding. Okay, all portions of the condominium property as originally installed, or replacement of like kind, any alteration of the condominium property or association property needs to be covered by the association's insurance. Excuse me. Any exclusions that are set forth in the statute are going to be the responsibility of the unit owner. And we'll talk about what those exemptions are probably on the next slide. If the association's insurance policy does not provide rights of subrogation against the unit owners in the association, an insurance policy issued to an individual unit owner may not provide rights of subrogation against the association. So this provides a list of those items which must be excluded from the association's insurance coverage. Those items will be the responsibility of the unit owner to insure. That includes all personal property, floor, wall, ceiling coverings, countertops, cabinets, appliances, window treatments, what have you. Those are all going to be the responsibility of the unit owner. Unit owners are responsible for the cost of reconstruction of any portion of the condominium property for which the property insurance and costs of any reconstruction done by the association is chargeable to the unit owner and may be enforced and collected in the same manner as assessments. I will let you guys read this information on your own. It has to do with some statute of limitations in making certain insurance claims. I will also allow you to read this information regarding managers. It has to do with when you need to have a licensed manager and certain duties of management. We talked about this, about not purchasing a unit after foreclosure sale. So recall of directors. Just know that you can be recalled for cause or without cause. Can be done by the members at a meeting or by written agreement. There are certain procedures set forth in the Condominium Act about once you receive the certain written agreements from the membership, having to hold a board meeting within 5 days to determine whether or not the recall is facially valid. The recent change here was that if the board fails to hold that meeting, the unit owner representative can file a petition for arbitration or can file a court action. That was the recent change that's notable here. Filling vacancies with regard to a recall. I told you that we would discuss this later. If a vacancy occurs on the board as a result of recall and less than a majority of the board members are removed, the vacancy is filled by the board. If the vacancies occur on the board as a result of recall and a majority or more is recalled, then the membership is going to be filling those vacancies in accordance with the procedural rules set forth by the division. This talks about how a board member can petition the validity of a recall once they've been recalled. As I mentioned earlier in the presentation, the division will not accept a filing for a recall petition when there are 60 or fewer days until the scheduled election. At that point, whomever is making the petition for recall just needs to wait for the election. Construction defect warranties, I will let you guys read this on your own time. Just know that there is a statute of repose, meaning the outside date at which a action can be filed. That here is 10 years from the date of substantial completion. There are some other warranties that are discussed here for certain improvements to the property, which if you guys can't sleep later tonight, you guys can absolutely read. Okay, termination of condominium. What's important to note here, and what's particular about terminations of condominiums, is that usually when we're attaining votes of the membership, we're not really concerned with our no votes. We're really concerned with how many yes votes do we get, how many votes in favor. Well, when you're presenting a plan of termination, you really need to be concerned about the no votes, and hopefully this, is an occurrence for many of your associations, but it may be depending. We've been hearing more about it from our clients, where companies are going in and purchasing multiple units, and boards are afraid of a potential termination coming down the line. The condominium form of ownership can be terminated. The plan of termination is presented to the membership, and it needs to be approved by at least 80%, and it can't be disapproved by more than 5%. If it's disapproved by more than 5%, you can't try for another termination for another 24 months from the date of rejection. The division has to approve a plan of termination. And in the event of total destruction, any unit owner can petition the court for judicial termination of the condominium. So now we've reached, I know that we're past our time a little bit, and I'm thank you everyone for sticking around. You will be rewarded with our discussion concerning Federal Fair Housing Act with a focus on assistance animals. So I know assistance animals have been plaguing association boards for quite some time. And the situation wasn't made any better by the issuance of a new guidance from HUD back in January 2020. A lot of people would hear, oh, I have under ADA, you're required to allow me to have this animal. But ADA isn't going to be applicable to our homeowners associations because we're all private residential or for the most part, private residential condominiums. There is an interplay between the two of them though. Under ADA, it prevents discrimination based on disability. There are lots of other types of discrimination under the Fair Housing Act. ADA applies to employment, public accommodations, commercial facilities, whereas Fair Housing Act, again, applies to private housing. Excuse me, so it's going to apply to our condominium associations. Animals under the ADA provides for only service dogs, which requires certain training. Fair Housing Act for our support animals, our emotional support animals, they can be any type of animal and don't require any specific training. ADA uses the term handy or disability. FHA uses the term handicap, but arose by any other name, smells the same, has the same basic definition. Under the Fair Housing Act, it is unlawful for a housing provider, here the association, to ask about the nature or severity of a person's disability, or if an applicant who intends to own or reside within the community, if they have a disability, or if a person associated with such applicant has a disability. An assistance animal is not a pet. It is an animal that works, provides assistance, or performs tasks for the benefit of a person with a disability, or provides emotional support that alleviates one or more of the identified symptoms or effects of a person's disability. Again, the FHA does not require that support animals, emotional support animals, have certain training or any certification. A lot of members will, or prospective buyers, prospective tenants, will provide a certificate from such and such association of assistance animal or association of United States service, whatever. Those certificates in and of themselves do not provide any substantiation of the person's disability or disability related need for an animal. While dogs are the most common type of assistance animal, other animals, other supports or emotional support animals can also be assistance animals. Assistance animals perform many disability related functions, including guiding individuals who are blind, smelling the breath of diabetes patients, providing protection or rescue assistance, pulling wheelchairs, providing emotional support. There are lots of things that these animals can do. So what types of assistance animals are there? You heard me mention them. There are service animals, and that's going to be your ADA type animal, a dog that's trained to assist someone with a certain aspect of their disability. And there are support animals, and that's really our emotional support happy pet. Under the ADA, a service animal is narrowly defined as a dog that's individually trained to do work for the benefit of a person with a disability. Performing work means that the dog is trained to take specific action when needed to assist a person with a disability. Providing emotional support and comfort, well-being, companionship, that's not work or task for a service animal. The work and tasks performed by this animal have to be directly related to the individual's disability. Determining if the animal requested is a service animal. This has double asterisks because it's based upon the guidance that was issued back in January 2020. And this is a fairly new way of analyzing requests for reasonable accommodations to pet restrictions or pet prohibitions. First, you need to ask, is this animal a service animal? Well, is it a dog? If it's dog, you continue with your inquiry. If not, it's not a service animal, but it might be a support animal. Is it readily apparent that the dog is trained to do work, perform tasks for the benefit of an individual with a disability? If yes, you can't ask any more questions. You have to say yes to the animal, to the requested accommodation. If not, is the animal required because of a disability? Yes, okay. Do they identify work or tasks that the dog performs? Yes, okay. Then you need to grant the request and you cannot ask for further documentation. If the animal doesn't fit these boxes, doesn't mean that it's not going to be allowed in your condominium. It just means that it might be a support animal, emotional support animal. If an animal is not a service animal, it may still be entitled to access if it's considered a support animal. A support animal is a trained or untrained animal that does work, performs tasks, provides assistance, and or provides therapeutic emotional support for a disabled person. Support animals are not required to be dogs, can be any common household pet, and there are certain circumstances where unique animals can be kept, but there is other documentation that you have to obtain that show that the needs can only be met by this unique animal. In order to show the need for a support animal, it is reasonable to request the written opinion of a physician, a psychiatrist, social worker, other health professional, which establishes that the applicant has a disability, which is most commonly defined as a mental or physical impairment that substantially limits one or more major life activities, and establishes that the assistance animal performs tasks or services for the benefit of the disabled person, or provides emotional support that alleviates one or more of the identified symptoms or effects of a person's disability. So we need to know that the person is disabled, and we need to know the disability related need for the animal. It is unlawful to discriminate against a person on the basis of race, color, national origin, sex, disability, familial status, and religion. It's highly case by case, fact specific determination. Local ordinances may also provide additional discrimination protections according to county code, like sexual orientation, maybe an additional protected class. There was a new statute that was created and amended. It's under our Civil Rights Act here in Florida. It is unlawful for a housing provider to require a person to pay extra compensation. That's also under the federal act. Can't require a pet deposit. Remember, these animals are not pets. Any weight restrictions, any number restrictions you have for pets are not applicable to these animals. An out-of-state practitioner providing supporting information must have provided in-person care or services to the individual on at least one occasion, and that practitioner must have personal knowledge of the person's disability and must be acting within the scope of his or her practice. Mind you, this is a state requirement. This isn't necessarily reflected in the federal regulations. If a person's disability-related need for an emotional support animal is not readily apparent, the housing provider can request reliable information that reasonably supports the person's need for the emotional support animal being requested. If they're going to have more than one emotional support animal, yes, they can have more than one. Surprise, surprise. They just need to provide information regarding the need for each animal. A housing provider can require proof of compliance with state and local requirements for licensing and vaccination. That's always going to be applicable. You know, just because you have the animal doesn't mean that you don't have to comply with certain health laws. Like a lot of people get surprised to hear that you can bring the animal to the pool, but you can't let it in the pool. Well, health code says you can't have animals in the pool. So yeah, bring them while you're sunbathing, but you can't bring them in to swim. A housing provider may develop and make available a routine method for receiving and processing accommodation requests, but cannot require the use of a specific form or notarized statement. And this is also true under the federal law. However, it has been shown to be invaluable for an association to actually have these forms and applications so that when someone does come to the board with a request, the association can say, hey, you know, in order to facilitate review of your requests, you know, we request that you provide us with this documentation. Here's our application, provides all the instructions. And you should definitely seek some counsel from your association's attorney who can help you in preparing these documents and adopting them. What is defined as a disability? Well, Lots of things can be a disability, certain psychiatric or physical, mental impairments can be considered a disability. What is considered a major life activity? Also a lot of things. Caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, working. All of these things are considered major life activities. Again, reach out to your association counsel whenever you're seeking guidance regarding these sensitive topics. It really is a case-by-case determination. So I think with that, we've reached the end of our presentation. Thank you all so much for sticking around. Don't forget to fill out your evaluation in the chat. You'll get that certificate, print out that certificate, give it to your association, whomever is the custodian for your records. I've had a pleasure, and we are doing, actually, Jeff had asked me to plug the amendments session that we'll be holding soon. And I'm sure if you go to our website, you can get more information about our upcoming classes. Thank you so much for joining me. It's always a pleasure. And whenever you guys are thinking about legal counsel, please think about K. Bender Rembaum. Give us a call. We're always here for you.
Danielle, do you have 5 minutes?
I have 5 minutes.
All right. I'm going to quickly go over some of the procedure for the evaluation. Click
Okay,
on the
good.
Q&A.
My voice needs a rest.
Yeah. I'm going to do a little talking now, but maybe go over a few of the questions that are pertinent to answer a handful of the questions. There are too many to get to all of them. Maybe we could do a handful of them. Those of you who are not required to stay on for the Q&A, you don't have to. That is not part of the credit process, but you're looking at the evaluation page. The link is in the chat area now. Before you fill out this evaluation, there's an opportunity on the top here. Click here for the course materials. That's where you can get the slides for today. If you're on the phone, look for the follow-up email tomorrow. We know you can't do this if you're on the phone, calling in. So tomorrow in your email, you'll get an email with the email you used to register for this event. That will have a link for this evaluation. And once you hit submit, you fill it out, hit submit, you'll then come to this confirmation screen, which also serves as your attendance certificate that you can give to your boards for filing as a condo certified board member. Note here on the bottom, it says to print this, right click and choose print. And then your printer box will open up and you can print it, and there you go. You have your certificate much more quickly than we've gotten it to you in the past. So with that said, you want to pick a couple of questions to go over?
Okay, so let's see. This Mitchell had asked 8-year term maximum years. Is that in one position, such as treasurer and then elected president? So this, Mitchell, is a trap that a lot of people fall into, where they think that officers and directors serve the same purpose. Well, they can be the same person, but you're wearing 2 different hats. And that term limitation is actually for board members. So it has nothing to do with being an officer, treasurer, president, what have you. It's your service on the board.
Cool. Here's a good one. That was a good one too. Not that wasn't a good one, but in an advisory committee, are there restrictions as to who can participate? And my guess is that advisory committees aren't making the decisions. They report to the board, correct?
Correct, yeah. That particular section of the Florida Not-for-Profit Act says that anyone can be on the advisory committees. The board committees have to have a majority of board members because they're acting on behalf of the board. Advisory committees anyone can be on an advisory committee. If you have members who have green thumbs and they would, you want to form a committee to advise the board on landscaping improvements, what have you, they create your committee. Those members can be on that committee and they can, decide, oh, we like these, whatever, and present it to the board.
Okay. And here's one, this refers to a slide earlier. Can a homeowner, okay, I guess not on the board, I assume this person means, can a homeowner request to see email communication between board members? So
again, emails between board members are generally not going to be official records of the association. So they are not going to be maintained as official records. that are accessible to unit owners. So
Just wanted to make that clear.
yeah,
Okay.
so no, you're not going to be able to see those generally because they're not considered official records of the association.
Okay, this one pertains to when you were talking about minutes at a meeting, and a lot of communities overdo, they write a novel for their minutes, and that's not necessary. You don't have to do that. So do questions asked at a board meeting by an owner, do they need to be recorded by name of owner on who asked the question, as well as the name of the board member who answered the question? Does that have to be in the minutes?
No, it doesn't have to be. It doesn't have to be that stringent. It can be. There's nothing prohibiting them from doing that, but you don't have to.
Okay. Let's see here. We'll do two more because there's so many, and you guys have got to be getting hungry if you haven't been eating while you're listening. So, okay, here's one that just with the pets versus the assistant animals. What is our power if an owner doesn't respect the service dog requirement and it appears to be nothing but a simple pet? What can a board do? Can we suspend their rights on amenity? What can we do?
So if the dog is presenting a nuisance, you can treat it like any other pet who is presenting a nuisance.
Even if pets are not permitted in the community? What if it's a no pet community?
You still have, typically you will always have general nuisance clauses for peace of enjoyment or quiet enjoyment of the property. And you can always send notices and enforce those nuisance provisions against that particular owner. If the animal presents a direct threat to persons or property, then you can exclude that animal. There are things you can do to address the situation. Again, contact your association's attorney because you really do want to be acting under the opinion of counsel because these are such sensitive issues.
Let's do one more, last one. And then if your question went unanswered, please don't take offense. Just again, way too many of them. And Danielle will get a spreadsheet containing all of your comments. And in the evaluation, if you'd like us to contact you, put that into the evaluation, ask your question there, and somebody will contact you. That is what we are known for. We get back with you. When you say the association has the right to access each unit, which you've mentioned earlier, does that refer to board members, the property manager, both, a maintenance person, a security guard? Who does it refer to? So
it does refer to agents of the association. They can get into the unit and do, whatever. If you have an engineer who's going in there to inspect the common elements,
like for the 40-year or whatever,
40-year, 50-year recertification, they can get into the unit. Now, do you want to have a board member present? That's entirely up to you. If you want to have management present.
Yeah, that's actually a great idea, because what we did in our associations when I was in my managing days, we would have one of our security guards for peace of mind to walk in with whomever. So that's something that the board can decide on their own, correct?
Yeah. And you know what? Recording things is so easy. If there really is a concern, you could always record the entry and to show that nothing untoward happened.
Okay. Well, thank you for your time. Great presentation. It's a lot of material. You probably
probably need
a gallon of water right now.
Yeah, I'm gonna guzzle some water, tea with honey, and you guys have the slides if you need to refer back. Absolutely do. But again, a lot of this information is just general information that can change based upon what's in your governing documents. Really, truly reach out to your association's attorney whenever you have an issue that may have a legal consequence for the association. So we're always here. Give me a call. My number's on the website.
KVRlegal.com. That's great, Danielle. Thanks again. You can take off. I'll stay on for another minute.